Why do nations trade? How do different theories explain trade flows? How is the international trade governed? And why do some countries liberalize their trade while others are more protectionist? Those are the questions that dominated the study about international trade, which will be addressed in this course, Politics of International Trade, with me, Poppy S. Winanti. In previous session, we discussed the evolution of the global trading systems since the end of the Second World War until the establishment of the WTO. In this session, we will discuss the international trade regime under the WTO, how the international trade regime is governed, and what the agreements are under this regime. The first question that we need to answer is what the WTO is. The WTO, or the World Trade Organization, is an organization that deals with the rules of trade between nations at the global level. The main purpose of this organization is as an organization for liberalizing trade. It is also a forum for the governments to negotiate trade agreements and a place for them to settle the disputes. In order to have a more comprehensive understanding about the WTO, we also have to know its principles. As we discussed previously, the WTO has adopted similar principles under the GATT. The first one and the main important thing is trade without discrimination. This reflects through two aspects. The first one is most favored nation, or it means treating other nations equally, and the second one is national treatment, or treating foreigners and local producers equally. In addition to that, the WTO also adopts several other principles. These include the first one, promoting trade liberalization gradually through negotiation. The second one is ensuring predictability through binding and transparency mechanism. And the third one is promoting fair competition or ensuring level playing field and encouraging development as well as domestic economic reform. After having basic understanding about the WTO and its principles, now we will discuss the agreements under the WTO. The agreements under the WTO can be categorized into three broad areas of trade. The first one is the General Agreement on Tariffs and Trade, which focusing only for goods. And the second one is the General Agreement on Trade in Services. And the last one is trade-related aspects of intellectual property rights, or TRIPS agreement. The General Agreement on Tariffs and Trade, or GATT, under the WTO is known as GATT 1994. This is to differentiate with the GATT after the end of the Second World War or before the establishment of the WTO. At that time, GATT was an international trade regime. The GATT 1994 is only one of the agreements under the WTO that deals particularly with trade in goods. There are many sectors governed under the GATT 1994, such as textiles, rules of origin, investment measures, etc. But in this meeting, we will only focus on agreement on agriculture and agreements related to standard and safety. The main objective of the agreement on agriculture is to reform trade in the sector and to make policies more market-oriented. This was intended to improve predictability and security for importing and exporting countries alike. There are new rules and commitments applied to three main aspects. The first one is market access, which deals with various trade restrictions on imports. The second one is domestic support in the form of subsidies and other programs, including those that raise or guarantee farm gate prices and farmers' incomes. The last one is export subsidies and other methods that used to make export artificially competitive. It should also be understood that the WTO has adopted what we call as safeguard measures. Safeguard protection refers to a provision that permitting governments under specified circumstances to withdraw or is to apply their normal obligations in order to protect or to safeguard certain overriding interests. Safeguard provisions are critical to the existence and the operation of trade liberalizing agreements, as they function as both insurance and safety mechanisms. Safeguard measures are also defined as emergency actions with respect to increased imports of particular products where such imports have caused or threaten to cause serious injury to the importing member's domestic industry. Regarding the safeguard measures, Article 20 of the GATT allows governments to act on trade in order to protect human, animal, or plant life or health, provided they do not discriminate or use this as disguised protectionism. There are two agreements related to these issues. The first one is Sanitary and Phytosanitary Measures Agreement, or the agreement that relates to food safety and animal and plant health standards. And the second one is what we call as the TBT, or Technical Barriers to Trade. This agreement tries to ensure that regulations, standards, testing, and certification procedures do not create unnecessary obstacles for trade. The next agreement is GATT. Trade in services is a new trade issue introduced under the WTO. However, despite it's a new agreement, it covers all internationally traded services. These include communication, construction, distribution, education, and all other things. Trade in services has different characteristics with trade in goods. Therefore, we need to understand four modes of supply under trade in services. The first one is Mode 1, or cross-border supply. It means suppliers provide their services in other territories from their home countries, such as telecommunication provider. Mode 2, or consumption abroad, means that consumers from overseas use or consume the services provided by the suppliers within their territories. For example, like foreign tourists visit other countries for tourism. Mode 3, or commercial presence, means that suppliers provide services by establishing companies or subsidiaries in overseas. This can be seen from, for example, banks open their branches overseas. Mode 4, or presence of natural persons, means that suppliers provide services by hiring or deploying foreign workers in their territory. For example, foreign consultants work in overseas. Trade-related aspects of intellectual property rights, or TRIPS agreement, is another new trade issue that was adopted under the WTO. It establishes minimum standards of terms and the scope of protection for a wide range of intellectual property rights categories, including patents, copyrights, trademarks, geographical indications, industrial designs, trade secrets, and others. The TRIPS agreement also incorporates all basic principles and previous international IP agreements, which are national treatment and MFN principles. The TRIPS agreement reflects the positive integrations or harmonization in international trade regime, since it requires its members to adopt the minimum standard of IPR protection in their domestic regulations. It should be noted that dispute settlement mechanism is not a new thing for the international trading system. A procedure for settling disputes existed under the old GATT, but it had no fixed timetables, rulings were easier to block, and many cases dragged on for a long time inconclusively. Therefore, under the WTO, it was adopted a dispute settlement mechanism that is more structured process with more clearly defined stages in the procedure, greater discipline for the length of time a case should take to be settled. The WTO also made it impossible for the country losing a case to block the adoption of the ruling. Under the previous GATT procedure, rulings could only be adopted by consensus, meaning that a single objection could block the ruling. Now, rulings are automatically adopted unless there is a consensus to reject a ruling. Any country wanting to block a ruling has to persuade all other WTO members to share its view. Nevertheless, although much of the procedure does resemble a court or tribunal, the preferred solution is for the countries concerned to discuss their problems and settle the dispute by themselves. The first stage is therefore consultations between the governments concerned, and even when the case has progressed to other stages, consultation and mediation are still always possible. In this meeting, we have discussed the agreements under the WTO. It was intended to provide the students with the basic understanding about the WTO and how international trade is governed after the establishment of this institution. However, it should be noted that international trade is not only governed under the global trade regime. As we have been witnessing, there has been the proliferation of regional trade agreements for the last few decades. In addition to that, the current global political economy situation has posed unprecedented new challenges to the WTO. The failure of the members to reach a meaningful trade agreement after its establishment, the significant increase in developing countries' role in shaping the negotiation process, the increase in the number and diversity of the WTO members, those contributed to the wide variety of their trade concerns, as well as the inability of the regime to respond to the current economic development issues. Those are some of the examples of the stagnation in the WTO. Some even consider that the current regime is facing the crisis of legitimacy. In short, with these dynamics, the future of the WTO remains to be discussed further. That concludes our discussion. Thank you for listening. With me, Poppy S. Winanti. See you in the next session.